E3 certain specialty occupation professionals from Australia. The E3 classification applies only to nationals of Australia. You must be coming to the United States solely to perform services in a specialty occupation. The specialty occupation requires theoretical and practical application of a body of knowledge in professional fields and at least the attainment of a bachelor's degree, or its equivalent, as a minimum for entry into the occupation in the United States. Eligibility criteria. To qualify for an E3 visa, you must demonstrate that you are a national of Australia, have a legitimate offer of employment in the United States, possess the necessary academic or other qualifying credentials, will fill a position that qualifies as a specialty occupation. Applying for an E3 visa from within the United States. The Form I-129, Petition for Non-Immigrant Worker, is used to apply for a change of status to obtain E3 Non-Immigrant Temporary Worker classification. Supporting documents. Your Form I-129 must include the following documents. A labor condition application, LCA, which cannot be the same application used in a previous H-1B application. Until the Department of Labor develops a new LCA for an E3, the applicant should use the standard ETA 9035 and ask that it be annotated as an E3 LCA. Academic or other credentials demonstrating qualifications for the position. Job offer letter or other documentation from the employer establishing that you will be engaged in a specialty occupation and that you will be paid the higher of the actual or prevailing wage. If required, before you may commence employment in the specialty occupation, you must have the necessary license or other official permission to practice in the specialty occupation. Applying for a visa with a U.S. Embassy or consulate. If your petition Form I-129 is approved, we will forward the Form I-797, Notice of Action, approval to the employer, who in turn will forward it to you. A Form I-797 approval notice is not a U.S. visa, as the visa must be obtained at a U.S. embassy or consulate abroad. After Form I-129 is approved by USCIS, the next step is to apply for a U.S. visa at a U.S. embassy or consulate, generally in your country of residence abroad. Please visit the Department of State, travel.state.gov or temporary workers webpage for visa information, how to apply procedures, and U.S. Embassy web contact information to learn more. Period of stay, extension of stay. Initial period of stay. Extension of stay. 2 years up to 2 years per extension, no maximum number of extensions, with some exceptions. Change of employment. Your new employer must file a new labor condition application and a new E3 visa application. The gap between the jobs must be 10 days or less. Note, Form I-129 is used to apply for an extension of stay or change of employment. Family of E3 visa holders. Your spouse and unmarried children under 21 years of age are entitled to the same E3 classification. Your spouse is entitled to work authorization, but not your children. To apply for work authorization as a spouse of an E3 non-immigrant, your spouse would file a Form I-765, application for employment authorization. For more information, feel free to call our law firm at 510-742-5887 or visit www.attorneyonair.com. This information is not legal advice. You should not act or refrain to act solely on the information provided.